Special counsel Jack Smith strongly criticized a recent order by the judge presiding over the case of former President Donald Trump's alleged mishandling of classified documents, saying that her request for jury instructions from his office and Trump's lawyers is based on a fundamentally flawed legal premise. In a court filing on Tuesday, Smith argued that the legal premise behind Judge Aileen Cannon's request is wrong and that it would distort the trial, potentially leading to a directed verdict in Trump's favor. The special counsel urged Cannon to promptly decide whether the legal premise in question represents a correct formulation of the law and indicated that federal prosecutors would appeal if the judge rules against them. Cannon last month directed Trump and the special counsel to submit jury instructions framed with two competing scenarios concerning the Presidential Records Act as it relates to the charges brought against Trump under the Espionage Act, accusing him of mishandling classified documents. The first scenario Cannon outlined allows the jury to review records and determine which documents Trump retained are personal or presidential under the Presidential Records Act. In the second scenario, Cannon instructed lawyers to draft instructions based on the assumption that presidents have the sole authority under the act to lawfully retain documents at the end of their term by declaring them as personal or presidential records, aligning with Trump's defense in the case. Both scenarios, he says, rest on an unstated and fundamentally flawed legal premise, namely that the Presidential Record Act, or the PRA, and in particular, its distinction between personal and presidential records determines whether a former president is authorized under the Espionage Act to possess highly classified documents and store them in an unsecure facility, like a garage in front of the Corvette. I'm sorry, did I say that out loud? Smith's team wrote in their filing, the Presidential Records Act requires the return of presidential records at the end of the president's term, but says that they can keep their personal records, which is described as documents containing highly personal information, such as diaries and journals and medical records. In a Tuesday filing responding to Cannon's order, Trump's lawyers maintained that the Presidential Records Act, or the PRA, gives Trump the authority to decide whether a record is personal or presidential, that all of the records found in his possession could be considered personal despite the classification markings, and that Trump's determination, he is the one that determines whether or not they're actually personal, but can't be second guessed by the courts because it was his determination. One of their proposed jury instructions was for the judge to tell jurors, quote, if President Trump designated a document as personal record under the Presidential Records Act, then the classification status of that document, if any, is not relevant to your evaluation of whether the government has met its burden of proving beyond a reasonable doubt that the document you're considering is a presidential record. Smith's office says such an instruction would be a grievous mistake and characterize Trump's defense using the PRA Act as pure fiction. Can't make this stuff up. For headlines or The Voice, this has been the Lockhart News Brief.